The North Carolina Court of Appeals is now back in session.
Thank you very much, Mr. Clerk. Welcome everyone to this session of the North Carolina Court of Appeals. I'm Judge Bryant, presiding over this panel. My colleagues are Judge Lucy Inman and Judge Billy Hanson. The three of us will hear this case today in re Meetze, if I'm not mistaken. Just a word about what we're doing here today. Obviously, these are unprecedented and uncertain times, and we are doing this virtual oral argument as a way to adapt to these times that we're in. Our Chief Justice Beasley has entered orders that allow us to try and proceed as fully as possible with our action while not endangering the safety of parties, of counsel, or personnel. And one of the orders is just this, providing oral argument in our appellate courts to proceed on this type of platform, this virtual electronic platform that we're using today. Counsel for both parties have agreed to use this platform, and we are so grateful to you for agreeing to do so, for your participation in this new reality, and for allowing us to proceed in this way. I may have mentioned, counsel, with the exception of Judge Inman, I think we're all doing this for the first time. So if there are challenges, we'll try to get through them. We have an IT person to help us with any electronic or technical glitches of that nature. Otherwise, we will proceed or try to as we do. So, counsel, are you ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
As I indicated, this is case in re Meetze. It is an appeal from Wilson County Superior Court, I believe. We'll hear from counsel for the petitioner appellant. There are two counsel, and if you would identify yourself as you give your argument.
May it please the court. My name is Mike Smith. My co-counsel is Ben Carter. We both practice in Rocky Mount, Nash County, North Carolina, with the law firm of Batts, and Bell, LLP. We do represent the petitioner appellant in this case, Ms. Candy Abel Peacock, who we will refer to as Ms. Peacock moving forward. We have reserved 5 minutes for rebuttal previously, which we would like to do. There were two arguments raised in our appeal in brief. The first issue deals with the Rule 60 order entered by the Wilson County Clerk of Court in April 2019. And the second issue deals with the trial court's order entered in September of 2019. I'm going to address the second issue, and Ben will later address the issue as to the Rule 60. Before we do so, I would like to give a brief recitation of the facts. This case has gone on for a little over 4 years, so I would like to just catch us up on the facts briefly if I can. Our client, Ms. Peacock, and the decedent in this case, Mr. Timothy Meetze, were married in South Carolina back in 1997. They lived together a little over a year until April of 1998. At that point, there was a serious act of domestic violence where Mr. Meetze abused Mrs. Peacock. That led to Mr. Meetze being charged for Mrs. Peacock obtained a domestic violence protective order at that time, and the parties never resumed the marital relationship after that point. Fast forward to 2001, Mr. Meetze moves to North Carolina, meets and marries a Miss Carol Burgess, despite still being legally married to our client, Mrs. Peacock. Mr. Meetze and Mrs. Burgess remained together, living as husband and wife until January 2016, when Mr. Meetze passes away. At that point, Mrs. Carol Burgess filed her application and assignment for year's allowance. Very shortly after that, our client, Mrs. Peacock, filed a motion to set aside that application and allowance, and also to void the marriage between Mr. Meetze and Mrs. Burgess based upon the prior marriage between he and Mrs. Peacock.
Can I just ask a brief question, because it's going to...
Yes, ma'am.
Is the last name pronounced Meetze or Meetze?
We've been saying Meetze. Ben, you may be able to
Oh, he's muted.
We've
Sorry
always
about
said
that.
that.
I've understood it's Metz from Carol Burgess. She was the lady that thought she was married to Mr. Metz, but wasn't because the divorce had not been finalized in South Carolina. So I've been told Metz.
We will pronounce it Meetze for purposes of this oral argument session, but I just wanted to make sure that was consistent. Thank you. Sorry for the error.
Sure.
No problem. So shortly after those documents were filed by our client in February of 2016, those matters were taken up by the Wilson County Superior Court. Judge Young entered an order granting the relief sought by Mrs. Peacock. Number one, voiding the marriage between Mrs. Burgess and Mr. Metz, and number two, setting aside the application and assignment of year's allowance in favor of Mrs. Burgess. Now, that was immediately appealed by Mrs. Burgess. It came to this court, and that appeal was pending throughout 16 and part of 2017. In July of 2017, this court then affirmed the trial court ruling voiding the marriage and setting aside Mrs. Burgess's assignment and application. Shortly thereafter, that in July of 2017, the appellees in this case, the bachelors, probated a will with the Wilson County Clerk of Court from Mr. Meetze, which named them as beneficiaries. Now, from that point in 2017 through the first of 2019, there were a few filings, but nothing major happened with the estate during that time period, we would say. The first of 2019, Mrs. Peacock's prior counsel had to withdraw for various reasons. At that point, Ben and I were retained. We began reviewing the file, and we observed that Mrs. Peacock's application, which was filed back on February 15th of 2016, was never executed or ruled upon. And what we guessed from that is, at that time, Mrs. Burgess's application assignment was pending, the appeal was pending, the clerk was possibly waiting to hear a resolution of that, and just for whatever reason, nothing was done. So on February 15th of 2019, we approached the Wilson County Clerk's office and raised this issue. On that date, again, February 15th of 2019, and it's kind of a unique situation because they originally filed exactly 3 years prior and on February 15th of 2016. But on February 15th of 2019, we approached the Wilson County Clerk's office. On that date, the assistant clerk executed both the assignment of the year's allowance and the deficiency judgment. However, she dated the deficiency judgment that day, February 15th of 2019, but she testified she dated the assignment February 15th of 2016 because she thought it was a mistake when it was not executed back in 2016. So she basically backdated it to 2016.
Can I just ask a brief clarifying question? When you say the assistant clerk or that the document was not executed or the assistant clerk executed the document, are you talking solely about the place where the assistant clerk signs? You're not saying it was not executed by your client initially upon filing, is that correct?
Correct, Judge. Our client signed and filed it back in 2016, but the clerk never executed the actual assignment.
Got it. Thank you.
Yes, sir. So at that point, that was the backdating issue was brought to the head Wilson County Clerk's attention. She chose to notice a hearing on her own accord set for April 1st of 2019. Following that hearing, she entered an order on April 4th of 2019 pursuant to Rule 60, where she ordered the dates on both the assignment and the deficiency judgment stricken and ordered they both be dated as of the date of her order, which was April 4th of 2019. Now, the effect of that was it restarted the time period to appeal, which allowed the bachelors, the appellees in this case, to appeal the assignment, which they immediately did. They filed a motion to set aside the assignment and deficiency judgment in favor of Ms. Peacock and further appealed the matter to Superior Court, as did we on the basis of the Rule 60 order. Subsequently, the matter was heard by the Honorable Marvin Blunt in Wilson County Superior Court in July of 2019. And Judge Blunt issued his order in September of 2019. And in his order, number one, he affirmed the clerk's order, the Rule 60 order, amending those dates on those documents, the application, assignment, and deficiency judgment. And number two, subsequent to that, he ruled that and granted the appellee's motion to set aside those documents because he found that our client, Mrs. Peacock, willfully abandoned Mr. Meetze prior to his death pursuant to North Carolina General Statute 31A1. And we, of course, appealed those two issues, and that is why we're before you today. At this point, I'll turn it over to Mr. Carter, and he can address the Rule 60.
Thank
The appellee's appeal of the assignment made pursuant to the year's allowance should be dismissed because it was untimely filed. The trial court erred in granting relief to the appellees pursuant to Rule 60. When acting on its own motion, it extended the time to appeal the assignment by changing the date of entry to April 4th, 2019, instead of the actual date of entry, which was February 15th, 2019. The only subsections of Rule 60 that are relevant to the facts for us today are subsection A, B1, and B6. There are 4 questions of law concerning Rule 60 before the court. The first is whether the trial court can make substantive modifications to an order pursuant to subsection A. The second is whether a trial court can grant relief under subsection B on its own motion. The third is whether a trial court can grant relief for a unilateral mistake that was not caused by misconduct under subsection B1. And the fourth is whether the trial court can grant relief under subsection B6 when the facts fall within the scope of subsection B1. Subsection A permits a judge to correct a clerical mistake in an order on her own motion. However, the judge is prohibited from making substantive modifications to the order. In food service specialist v. Atlas Restaurant Management, the judge entered an order with an incorrect date of entry. The judge on his own motion then changed the date of entry not to the actual date of entry, but to a latter date. The order was appealed within the time permitted based on the latter date, but the appeal was untimely filed based on the actual date of entry. This court held that the correction of an errant date of entry to a date other than the actual date of entry constituted an improper alteration of the substantive rights of the parties because it extended the time period to appeal.
So let me, on that point, what is the effect of the date of the backdating by the assistant clerk? What is the exact substantive impact of dating the document to 2016 versus 2019? Like how does that impact either your client's ability to recoup those funds or that Mr. Eagle's funds?
Yes, and that issue was taken in food service specialists, and they held that the change of the date of entry to a date other than the actual date extended the time to appeal, and the court held that the time to appeal is a substantive right.
But there's no dispute here as to when the assistant clerk actually entered the orders, as it were. I mean, the date is pretty well set in stone. So I guess I'm trying to see even more fundamentally specific to this case within the context. I'll call it an estate proceeding for simple terms. What is the impact of dating the application and assignment of year's allowance and sworn and subscribed to in 2016 versus 2019? What is the real world impact of that on parties in this case?
Had the clerk entered the correct date of entry, the time to appeal would have expired, and the respondents would not have filed a timely appeal. Yes, ma'am.
I just want to make sure, these dates can get confusing.
Yes.
The assignment was pending since 2016. On February 15th, 2019, assistant clerk backdates that document to 2016.
Yes, ma'am.
And then on that same date, deficiency judgment on that date.
Mm-hmm. And the deficiency judgment had the correct date.
Right. Then this goes to the clerk, who hears it on April 1st, and who determines that the assistant clerk made a clerical error, and then made an error. Mr. Eagles is shaking his head. Determined something which I'll hear about. The clerk said this assignment of allowance should be dated on the date the assistant clerk signed it. Or I would think that's what food services would hold. I'm getting behind myself, I guess. The clerk, what date did the clerk
Yes, so the clerk did not say whether this was a clerical mistake or a substantive mistake. So she just called it a mistake.
Okay.
And what the clerk did was change the date from 16 to April 4th, 2019.
Okay, so the clerk changed it to a date that was sometime after this hearing, but that was weeks after the date that the assistant clerk had signed the
Yes,
document.
ma'am.
Okay,
That's
thank you. I just want
correct.
to make sure I understand. So we've got a date in 2016, we've got February 15th, 2019, and then we've got April 4th, 2019. And when you're arguing about the time to appeal, just to be clear, because we're an appellate court, but this was an appeal to Superior Court, your argument is that that the clerk erred in dating the assignment of the allowance on April 4th, that really the assignment of the allowance should have been February 15th. And by virtue of that, when the appellees appealed
To the Superior Court.
from the clerk's order, the statutory 10 days allowing an appeal from the clerk's order, Superior Court had expired.
That's correct. And this court held that if the clerk was acting under subsection A, that is, if the clerk was viewed this as a clerical mistake, then the only way the clerk could change the date would be to February 15th, 2019. So if it was a clerical mistake under food service specialist, you could change the date, but only to the actual date of entry, which was February 15th, 2019.
But the clerk didn't say this is definitely a clerical mistake.
She said it was a mistake, and that is it.
If I can just one more, if this panel agrees with your argument about this issue, is it your position that we do not reach the second issue in this case?
That's correct.
Okay, thank you. Thank you.
In regards to subsection B, subsection A of Rule 60 is the only subsection that can be applied because the motion was made by the clerk of court and not a party to the action. This court held in Sotelo v. Drew that only a party to the action may request relief pursuant to subsection B. The language of subsection A specifically permits a judge to grant relief on his own motion. However, that language is completely lacking from subsection B. There are a number of cases where this court has stated in dicta that a court can act on its own initiative pursuant to subsection B. These cases properly allow the trial court to consider the substance rather than the form of a party's motion, but incorrectly state that a judge can bring its own motion under subsection B.
Are you referring to are you going to address the Pope v. Pope case?
Yes, ma'am. And there's a couple of other cases along that line. In some instances, the court will grant relief under Rule 60 if the party doesn't cite a particular subsection of Rule 60, or even if they fail to cite Rule 60 in its entirety. In Pope v. Pope, this court permitted relief to be granted to a party under subsection B5, even though they requested relief under subsection B6. The court reasoned in part that if a trial court can act on its own pursuant to subsection B, then surely it can act pursuant to subsection B5 instead of subsection 6. In reasoning that a court could act on its own motion, this court relied in Pope on Haib v. Lowry. In Haib v. Lowry, this court held that a superior court judge cannot modify the order made by another superior court judge. In the opinion, the court expressly stated that the modification would have been proper if a party had made a Rule 60 motion or if the trial court had purported to act under Rule 60 in its order. In Haib, this court relied on Carter v. Clowers as precedent for the position that a trial court could act on its own motion pursuant to Rule 60B, even though 60 was not cited by the parties. In Carter, the party requested relief under Rule 15A, but the court granted relief under Rule 60 instead. There is no authority for the position that a trial court can act on its own motion pursuant to subsection B. The precedent does allow a trial court to grant relief requested by a party if they fail to use the correct form, but does not permit a judge to make its own motion. To allow a judge to move under subsection B ignores the plain language of Rule 60.
So going back to sort of that initial question, was this a correction of a clerical error, or was it, more under 60B, a ruling that kind of impacts the substantive rights? I guess I'm trying to get to that basic question. Was this a clerical error in putting the 2016 date by the assistant clerk, or is there some substantive impact, not just rights of appeal, that kind of thing, but like some substantive impact? Did that impact the amount of allowance, for example, your client was entitled to? Does that impact the amount of deficiency judgment? Those sorts of things. So was this a clerical error? Just the clerk made a mistake, should have dated it the current date, not the prior date, or is there an actual real world impact to the bottom line here in this case?
This is a substantive error because the time to appeal was changed. And that's why the clerk can't.
So the time to appeal begins to run in February 2019.
February 15th, 2019.
Right. And the error you're asserting there is that the clerk's order in April then extends it 10 days from April 2019. So there's I think the substantive error you're alleging. I'm going back and like, what is the actual real world impact of the assistant clerk dating this one form, the assignment of allowance, in 2016? Like, does that really matter in the grand scheme of things?
The time to appeal should still be based on the actual date of entry, which would.
Are you saying that they had to appeal by, I don't know, February 26, 2016?
2019.
Okay, so I'm asking about the 2016 date. Why does the assistant clerk backdating it to 2016 matter in this case? Like, what does that do?
Okay, it matters because the clerk backdated it. It then gave the respondents are now able to file a Rule 60B motion to have it corrected. Had the error not occurred, Rule 60 wouldn't be an issue, and the time to appeal would have expired.
Sorry, just to make sure. So the assistant clerk said, I intentionally backdated it to this date. It's like, oh, I forgot what year it was. I intentionally backdated it to this date. If the clerk had, through a scrivener's error, if we all agreed that it were a clerical error, and I'm not saying it was, if we all agreed it were a clerical error, then wouldn't the clerk's later order be under Rule 60A so that the clerk could do that? Maybe I'm mixing up the issues in this case. When we talk about sua sponte, are we talking about what the assistant clerk does or what the clerk does?
So if the clerk is correcting a clerical mistake, they can act on their own motion pursuant to 60A. And what they're permitted to do is to change the mistake to the actual date of entry. They're not permitted to change the date of entry.
And that's the food specialist case.
That's the food specialist case. And then you have, if you cannot proceed under subsection A, you analyze subsection B. And this would be a substantive mistake would be analyzed under subsection B1. Now, again, the court cannot reach subsection B because the clerk filed a motion. A party did not file a motion. But had a party filed a motion, that would be proper to analyze a substantive mistake under subsection B1. B1 permits a court to relieve a party from a final judgment for mistake, inadvertent, surprise, or excusable neglect. Your Honor, I'm getting short on time. Can I have an extra five minutes, please?
You can have an extra 5 minutes. You can have, you still have 8 minutes.
Okay.
So you can use 2 more or 3 more before your rebuttal, or you can finish with the three last.
Your Honor, subsection B1 can only be used for a unilateral mistake if the court finds that misconduct occurred. The trial court specifically found in this case, in the finding of facts, that the error was unilateral, that it was committed by the assistant clerk, and that there was no ill will on the clerk's part in committing the error. Because the trial court made that finding, relief cannot be granted under B1 because misconduct did not cause the unilateral mistake. Under subsection B6, B6 can only apply if one of the 5 preceding subsections do not apply to the facts. Because this is a mistake that clearly falls within the scope of subsection B1, the B6 cannot be applied. In Bruton v. Sea Captain Properties Incorporated, this court affirmed the denial of a motion based on B1 and B6 because the motion was solely based on the neglect of the movement's former attorney and was filed outside of the time allowed for a B1 motion. The relief granted to the respondents under Rule 60 has not affected justice, but has given the respondents a windfall. Relief granted did not cure the harm caused by the mistaken date of injury, but put the respondents in a better position than they would have been had the mistake not been committed. In En re Estate of Archibald, the court affirmed the dismissal of Devise's appeal as untimely, even though the Devise argued that it was impossible to file a timely appeal because it had not received notice of the year's allowance. The court affirmed the dismissal, reasoning that this legislature intentionally did not impose a notice requirement with respect to the statutory right to use allowance. Furthermore, the respondent's own decision has resulted in them being placed in a position where their year's allowance could have been filed and the time to appeal expire without them receiving knowledge. Once the petition was determined to be the surviving spouse, the respondents immediately filed the will wherein they were named as the devisees. At that point in time, they could have petitioned the clerk to deny the pending petition for the year's allowance or to appoint an executor to do the same. They did not do it, and they chose to bear the risk that the year's allowance could be filed and the time to appeal expire without them receiving notice. It's for this reason the trial court's decision should be reversed and the respondent's appeal dismissed as untimely.
Briefly, if I could.
On the second issue. Excuse me, go ahead.
Yes, Your Honor. I'd briefly like to cover the second issue. Again, if the court rules for us in issue 1, the appeal would be untimely and it would be no need to get to issue 2. But if you get to issue 2, we believe this is a major issue, and we said it was an error of the law basically for the trial court to find that our client, Mrs. Peacock, willfully abandoned Mr. Meetze without just cause. The petitioners, in their motion to set aside.
I'm sorry, just keep interrupting. The trial court determined that she willfully abandoned him without just cause. That she intentionally left and then did it without just cause. Is the without just cause you're contending a conclusion of law that's subject to de novo review?
Judge, we believe the application of the facts to that law and the concluding as a matter of law that she willfully abandoned him without just cause, we would argue that's an error of law to be reviewed de novo. Argument. And you're correct, Judge. And if I could refer back to Judge Blunt's order from the trial, this is included in paragraph 115 of the record, paragraph 3. As a finding of fact, Judge Blunt specifically found that our client, Ms. Peacock, involuntarily and unwillfully separated from Mr. Meetze on April 23rd, 1998, following Meetze's acts of domestic violence committed against Peacock. So in that finding of fact, he specifically found it was not willful and it was not voluntary. But later on in his conclusion of law, he then says that based upon the passage of time, that somehow transformed into willful behavior, Judge. And what we would argue is that's just not correct, and that's an error of law. I mean, there was a lot of...
If we can talk about that willful
question. Okay.
With the trial court saying because of the passage of time, this was willful abandonment. My understanding of the case law is that is an issue of fact. Is your understanding different? Not about the without just cause, but just about about the intentional, the finding of intentional. Isn't that a factual issue?
Judge, I could see where that would be a kind of a mixed question of law and fact, but we focus on the application to that law as being an error law, and that's what we argued in our brief, I believe. Because, I mean, we state that, you know, if you look at the reasoning behind that, it's almost like the court saying our client, Mrs. Peacock, should have reunited or gone back to Mr. Meetze, despite the abuse that she suffered. And there was a lot of testimony and evidence presented during the trial that she sustained 2 black eyes, you know, a chipped tooth, bruising about her face. You know, there was blood on the carpet. There was a picture introduced about that, medical records, the domestic violence protective order hearing. We would argue there was clear evidence that showed that her separation from Mr. Meetze was involuntary, it was unwillful, and it was compelled. We cited several cases, Barnes v. Singer, which defines what is voluntary, although it doesn't exactly apply to this case. Mears v. Jernigan, State v. Talbot, both address the issue as willful abandonment. Specifically, State v. Talbot deals with domestic violence. And the court there found that affirmative acts of domestic violence constitute constructive abandonment, and the fault then lies with the abuser.
I think you indicated that the trial court actually made a finding that that her leaving was not willful, was
Correct.
voluntary.
Correct, Judge.
In this order?
Yes, ma'am. If you look at page 115 of the record, paragraph 3, that's where that's included.
So that finding is inconsistent with that particular one with the court's ultimate holding.
Right, Judge. It directly conflicts with the conclusion of law that she.
Do you think the judge was really trying to reach what we sometimes in the law consider an equitable result here, as opposed to a strictly legal one? I mean, we
can understand that.
But
Yes, Judge. I mean, this case is certainly an example of what can happen when 2 married spouses don't take the proper action when they separate and either obtain a divorce or obtain a separation agreement. That is true. However, I would argue the law in this case, 31A1, is clear. That the only question is, was our spouse, the lawful spouse of the decedent at the time of his death? This court has affirmed that question back in 2016. She was. So the only other question is she barred by law from taking? And we would argue the facts and that finding the fact in Judge Blunt's order says she is not barred and she should be able to take. And we'd just like to reserve, you know, a few minutes if we could.
we don't have time to reserve, but we will give you 2 minutes rebuttal because we did have a number of questions. So 2 minutes rebuttal. And we'll hear from the appellee.
May it please the court, Ben Eagles on behalf of respondents appellees Blair Batchelor and Jordan Batchelor. The first thing I'd like to do is correct the statement that was made. The Batchelors did not file this will for probate. My client, Carol Burgess, did. She was the lady that thought she was married to Mr. Meetze, but wasn't. Once it became clear she was not the widow of Mr. Meetze, she has no further part in this because she's not married to him. So all she had was the will and she gave it to the clerk. She could not probate it. She couldn't do anything about it. So Jordan and Blair Batchelor, the folks that are the respondents, did not do that.
Can you explain, because I couldn't see in the record, the relation of the Batchelors to Mr. Meetze? He was married 3 times.
The Batchelors are children of a godmother's husband. So the Batchelors are, I think, in their 20s, and their parent was the husband of Mr. Meetze's godmother. So what happened in the will is Mr. Meetze left everything to who he thought his wife was, and if she couldn't survive him, she left it to the Batchelors because that was his godmother's kids.
So they were residual beneficiaries.
Yes, Your Honor.
Thank you.
Okay, and let me go straight to the 60B argument. Pope v. Pope is completely on point here. This was not a clerical error. The clerk testified in Judge Blunt's hearing that she thought that the date had been left off in 2016. She thought when she signed this paper on 2/15/2019 that, oh, we forgot to do this 3 years ago. And no, they didn't forget to do it 3 years ago, because 3 years ago, there was a spousal support order in place already for Ms. Burgess. And so she was wrong and admitted that. And she said, you're right. I thought that we just had left it out. I hadn't. So then she put the date of 2/15/16 on there. Well, the problem there is, with that date, my folks have no right of appeal. And if I were to come to y'all now and say, well, you know, she put it on the 16th, 2/15/16, it should have been 2/15/19, we'd all be looking at a record that was wrong. You'd be saying to me, well, Mr. Eagles, the record says it was filed in 2/15/16. What's going on here? And so when this happened,
Would you perhaps argue the clerk made a mistake in backdating it, number one, and number two, we all know when it was entered. It was entered when it was signed. That is the law, and therefore we do have time from that date.
well,
We do have time from that date, isn't that correct?
I disagree with that statement, Your Honor. What I'm arguing is on its face now we have an improper record. And nothing can be done with an improper record, because when we come to you, then y'all are just as confused. You'd be even more confused than you are now. You'd be saying, hold on, what's going on here? We've got a record with improper dates on it. And so we contacted the court with the clerk. We got on a conference call. Mr. Smith and I got on a conference call with the clerk to say, we got a problem here. So, you know, we almost did make a motion. We didn't put it in writing, but we contacted her and said, we've got a problem here. We can't appeal from this because the day it was entered, it was 3 years old. And so what she did under Pope v. Pope, the grand reservoir of equitable power, she used 60B, which it says right in the case. A 60B doesn't even have to be specified which one it is, 1 through 6. And a superior court can make it on their own, or a clerk can make it on their own. Additionally, if you look at what the clerk did, if you go back and do what they're asking, then my clients have lost their due process rights. Because if she doesn't change it from 2/15/16, they were out of luck by 2 years and 45 days, whatever it is, the day it got entered. We go to her and say it's the wrong, so we can't appeal then. So we go to the clerk.
And as of that date, you're calling the clerk, you and Mr. Smith are calling the clerk, say, we've got a problem here. It doesn't get heard by the clerk till April 1st. So is your argument also, it's an impossibility. It's just an impossibility because, you know, maybe if the clerk had heard you and made a ruling the next day, it wouldn't be so bad. But it was weeks later.
Well, yeah, the point is if the record is done as they would ask you to do the record, there's never a time that my clients could appeal timely. They couldn't appeal timely after it was first entered with an incorrect date because it was already 3 years old. Then when we go to the clerk and say we can't appeal this because it's already 3 years old, she sets a date for it as she can under Rule 60. I mean, to do what they're asking you to do is to say the bachelors have no right of appeal here. They've just missed out on their appeal because the clerk made an error. Let me say that again. They're asking you to take away the due process rights of my clients because of an error that the clerk made. And certainly, I don't.
Sorry. Did your clients have actual notice of the entries of the orders in February 2019 of that date? Were they on actual notice?
No, sir. No, Your Honor.
When did your clients, if the record reflects it, when did your clients gain actual notice of the entry of the assistant clerk's orders in 2019?
I don't think that is in the record, but I think it is fair to say that they did not get notice of that with any kind of timely time frame.
You did.
No, ma'am, I did not. The first time I found out about this was when Mr. Smith contacted me after 10 days had gone past from the 2/15/16 entry, which was incorrect. And he said, your lady's out of luck. You've got to give us the property. There's property that's an issue.
So this
That's
wasn't
what
a
matters.
situation where, okay, very well. And I'll just say, you know, I think you conceded with Judge Blunt. Do you concede that, assuming we agree with you on this issue, that if we agree with you on this issue, do you still have to address issue 2?
Yes, Your Honor. Yes,
I'm
Your
just
Honor.
saying that because this is a complicated case and my wordy questions are taking up time. So I don't have any more questions for you on issue 1. My colleagues may, but don't forget issue 2. If you,
The final thing I would say, again, is just what I've said. At the date that this was entered, the clerk was incorrect. It wasn't a clerical error. She put the wrong date because she thought it hadn't been done properly in the past. So she made that error. It was correct to correct her error and put a date on it so that anybody that had rights of appeal would have that right of appeal. And that's just all we're saying. Otherwise, you're telling the bachelors, you know what, the clerk made an error. And by the way, she made the error corrected, you lose all your due process rights. You don't have any right of appeal because you didn't have it when it was entered 2/15/16 because you're already way past 10 days then. And now they want them to go back and put it 2/15/19. And by the time that was heard in April, that was already too late. So that's our point there. This was an error by the clerk. It was not a clerical error. And this is not a food services case. In the food services case, they were in open court. An order was entered, judgment was entered, and then the judge forgot to sign it or something, and later on entered it and signed it on that date, and it was ordered, and so it gave a different date. Nothing was entered here in open court like that. So food services case does not have anything to do with this case. Again, that case.
Is there any dispute that your clients were, that the clerk was required to provide notice, that the assistant clerk was required to provide notice to you of?
The clerk was not required to give us notice. That's not the point. No notice is required, but with the way it was handled and the dates they put, whether you have notice or not doesn't deal with their rights. They have rights under the statute within 10 days to appeal this. Well, the way the clerk has entered it in the documents, there was never a 10-day notice that they could have unless she enters it April 1st.
If the assistant clerk had properly dated this thing, February 15th, 2019.
Correct.
Your clients didn't have a right to notice of that.
Correct.
And Mr. Smith calls you more than 10 days later.
Correct.
Then would you just be out of luck?
Correct.
You didn't know. Okay, thank you.
But that argument is saying we can take away your due process rights because you wouldn't have gotten notice anyway. That ain't America. You know, the notice and whether you have notice or not does not go to the due process rights.
Thank you.
And so that's, and again, food services, you can look at that. That's a case where in open court, an order was entered, it had a date, and the judge just changed it later because he just signed it later, or it was just a change that he made. This case is different where they made an error and it was brought to the attention of the clerk. And that's important. You know, the clerk didn't just come out of nowhere and change this. We brought it to her attention and she had a hearing. Well, the hearing, you know, she called after we called her on the phone to say we need to do something about this. But anyway, she could do it on her own, even if we hadn't called her or hadn't made a motion, according to Pope v. Pope. And the rule otherwise is just to ignore the case law that deals with this directly and speaks to it directly and say that these folks are out of their property rights or right to appeal, which is a due process right because of the clerical error. Because of an error made by the clerk, not a clerical error. And then to jump to the part about abandonment, I agree. Page 115 in the record, initially, when Ms. Peacock had the domestic violence issue, she was separated involuntarily and unwillfully. And I don't disagree with that. What happens is if you look on page 115 in 4, 5, and 6, she twice, in addition to that, filed for divorce from him, but the divorces were not finalized. And she had the second divorce, attempted divorce, pending when he died in early 16. She also lived with at least 2 different men, she testified, in an adulterous relationship. She testified to that.
Did Judge Blunt hold that it was because of an adulterous relationship that he was determining this case? Because as I read it, he was talking about the passage of time and the lack of contact transforming an involuntary separation into a willful abandonment without just cause.
Your Honor, I think you read it the same way we do. Yes, in number 5, it says, after separating from John Timothy Meetze and prior to the death of Mr. Meetze, she had lived in adulterous relationships. And then he says in number 6, based upon the passage of time and her involuntary separation to include her divorce filings as well as lack of contact, he did willfully and without cause abandon John Timothy Meetze. But there's 2 different reasons, as you've seen in my brief. If you voluntarily leave someone and live with another person in an adulterous relationship, you lose your rights. Or if you abandon them, you lose their rights. So as you can see in my brief, 2 different reasons why.
Looking at
You'd like to ask, how can you have it both ways? How can you, and it sounds like here the trial court tried to have it both ways by indicating there was an involuntary separation.
No, Your Honor.
Not a willful abandonment. And then
I think, Your Honor,
it turns into, because of her living conditions thereafter, even though she's gone, it turns into a willful abandonment.
that's not, no, his order is not inconsistent. What he's saying is, and it makes sense. Yes, when she first left him, it was because of domestic violence matter. But later, and if you look on in the transcript that's been provided, on page 49 of the transcript, lines 9 through 13, I said, do you know why, asking Ms. Peacock, the ladies here that's trying to get the spousal support, I said, do you know why the divorce in 98 was not completed? She said, yes. He answered my lawyer and wrote a letter to her, and when he was in prison, and said that he loved his wife, didn't want a divorce, and I think that was it. So
Were they ever actually reunited?
Not to my knowledge. Not to my knowledge.
So if we can go to the without just cause element, so we've been talking about the willful abandonment. Do you agree that without just cause is an issue of law subject to de novo review by this court?
Well, I think that's a mixed issue of what the facts are compared to that to determine the facts.
So you're not aware of any case law saying that that is an issue of law?
Your Honor, I'm not aware, and I don't want to speak incorrectly. That's something I can look at. But
you would agree, though, if, for example, the willful abandonment were an issue of fact, which I don't think Ms. Peacock even challenged, but assuming she had, if it were an issue of fact, it's an abuse of discretion standard. But that if the without just cause is de novo, I mean, is a matter of law, then it's a de novo standard?
I agree with that. Yes, Your Honor.
So it seems like one of the key questions here is when you, at what point in time do you determine, willful abandonment, right? Is it on the date of separation, as it were, or as Judge Blunt finds, is it something that kind of morphs over time?
Completely, yes.
So that's one kind of question. The other thing is, as you talk about this, if we get into this, yes, it morphs into that over time. It seems to me it sort of ignores the elephant in the room, which is that it's not as though Mr. Meetze was waiting around for Ms. Peacock to come back home, right? I mean, he's engaged in a bigamous marriage.
He was in jail, Your Honor, when this happened. He was in jail for several years, so he couldn't go anywhere.
Years and remarried. I mean,
2001.
Not a valid marriage, but he remarried. So, I mean, how do you get to willful abandonment where it appears, allegedly both spouses are engaged in what is purportedly extramarital relationships and extramarital marriages?
Well, I don't think his extramarital marriage excuses her abandonment the same way it doesn't excuse her involuntary separation. I mean, again, if you go back to the fact that she started a divorce proceeding and that he says, no, while in prison, I love you, I don't want to divorce my wife, and so she doesn't. that is a point of fact that is something to take into account here as to what's going on. So, for instance, what I would say is,
Sorry, do you take that into account, her saying that? You know, he said he loved me, he didn't want to be divorced. You take that to mean she changed her mind and decided to not go through with the divorce at that time?
that's what she said, Your Honor.
Okay. And for all the time he's in prison, if she didn't willfully abandon him on the day she fled the home, is her separation from him willful when the state of North Carolina has physically separated him from all of us here who are not in jail?
I don't think so, no.
So it couldn't be then. Couldn't be till after he was out of prison, right?
I think that's fair, yes, Your Honor. So, and additionally, the thing she said, and this is on page 47 of the transcript, is when I was talking to her, she said that she had intended to leave him, page 47, line through 18 through 20. She said the last time she saw him was in 1999. She said she had lived with 2 other men and had sexual relations with them. And she said that Tim said he didn't want a divorce when she tried to have a divorce.
Can I ask you about another elephant in the room?
Yes, ma'am. Yes, Your Honor.
Why in the world would someone who's been physically abused to the point of the 2 black eyes, the chipped tooth, and has fled the marriage, and then the spouse who she fled has been in prison, why in the world would she think if she went back to him that she would not be abused again?
I don't know why
Does
she,
that matter?
I don't know why she, not from this legal standpoint, I don't, Your Honor. What you're getting at is exactly right. And I don't disagree with anything you just said. I would expect that if she was abused, that she didn't want to go back because she felt she'd be abused again. But with all due respect, I think she's trying to have it both ways. If she is leaving him because of this and what happened involuntarily and unwillfully, that's fair. But I don't think that she can say that after she said she's not going to divorce him and after she leaves voluntarily to live with other men, that she is not with him because she's scared. She's chosen at that point to get away from him. And if I may,
How do you know that? How do you know? How is it mutually conclusive that she is scared of him and that she is moving on
it's not.
with her life as best she can? He asked her not to divorce him, and she didn't.
I don't disagree with that, Your Honor. I don't disagree with that. The point I'm making is, and understandably, when it comes to abuse of a woman, that's horrible. I have 2 daughters. I'm not, that is awful. And everything you've said about abuse and how you react to it is true. But I don't think it's fair to these potential beneficiaries to say that, well, Miss Peacock, since she left him and was moved apart from him because of domestic violence, that we don't look at anything else that came after that. We don't look at the fact that she lived with other men voluntarily when she had an opportunity to have a divorce and chose not to. And also had a divorce pending that would have gone through, but for his death. And earlier, the court made it, I think you hit the nail on the head, about the equities of this case. Miss Peacock admitted in court, just as we all know, that Mr. Meetze didn't have any property when she left him. He was incarcerated, and that she hadn't seen him since 1999, was married to him for a year. And now what happened in 2016, she came to his funeral, and Mr. Meetze's wife, that was not his wife, threw that lady out. Because Mr. Meetze said, with all the things that had happened, he didn't want to have anything to do with her at that time. He was dead. I don't know. She told me that. So that's just hearsay. And so,
and when you look at that case, which was our earlier case,
right.
Certainly I can't think of many things worse than losing your spouse than finding out he was married to someone else. And I understand that. So Some people might argue that Ms. Peacock paid some serious dues. And
Yes, Your Honor,
is
but
legally entitled to recover in this way. She's not getting a windfall that she didn't deserve.
and that is the part I would disagree with. What she went through was horrible and should not have gone through. And what Mr. Meetze got to pay for that was to go to jail. But the purpose of 31A, if I may say, is so that when a spouse is abused and is out of the house and the husband dies right after that in some kind of normal time period, then she's not going to be cut out, because you're going to say, I wasn't in the house, I didn't abandon him. But when she leaves and he doesn't have anything, and it's been 17 years, and she's filed for 2 different divorces, and she's been living with other men, and then she's going to come and take what would have gone to these other folks that are innocent third parties. You know, Mr. Meetze got what was coming to him by going to jail. You know, what he did was terrible. He was found guilty of it, and he went to jail.
Well, I'm still struggling with this concept of you know, as it relates to Miss Peacock, we are to, or the trial courts, to view all the circumstances up until the date of this hearing on whether there was willful abandonment or not. Your argument seems to be that we should stop paying attention to the circumstances as it relates to Mr. Meetze upon the date he's released from jail. And it seems to me, if we're looking at this concept of willful abandonment, that is one party abandoning the other. Here, it appears to have been a mutual abandonment. You know, both parties engaged in relationships outside of their marriage. As you say, the second divorce probably would have gone through mutually, but for Mr. Meetze's death. I guess I'm having a hard time squaring how we only look at one side of the equation versus both sides of the equation when it comes to abandonment as a legal concept.
No, I would agree with Your Honor. They both abandoned each other. So Mr. Meetze, if he had outlived her, wouldn't be able to take anything from her. So let's flip this around. If Miss Peacock had died back in 2016 and Mr. Meetze rolled up and said, oh my gosh, I'm not married to this lady, I want to go get something from Miss Peacock's estate, I think he'd be in the same position of abandonment. It was good for the goose is good for the gander. Nobody should get anything.
Except for, no. He beat her and she left because he beat her.
Right.
So, and I understand he's paid his debt to society, but how can that be in the same? I'm happy.
It's not. And I think that's part of the issue with this domestic violence. When we hear about domestic violence, we are rightfully shocked to our being. How could a man hit a woman? How could a man hit his wife, somebody he loves? This is just awful and terrible. But the law is what it says. I would agree that his abandonment of her was less induced by her, or she has less reason for it, or less culpability. I'm not saying they're equal. It just in response to the court's question about, well, we can't have it both ways. I agree. I would say that neither party should be able to take from the other's estate in this situation. I would say that the fact that she was beaten means initially when she left him that was involuntary, and I agree with the judge's order. But I think that the things that happened over the next 17 years put it in that position, both legally and equitably, where we say, yes, you were abused and that was wrong and he went to jail, thank goodness. But that doesn't mean that these folks are going to lose their rights to what might have been left to them through not even being able to have an appeal, or that she somehow should deserve more from his estate when he didn't have anything when they were together for 1 year. And I can see, and that was what was argued by the defense. Excuse me, not defense, but by Mr. Smith to Judge Blunt. He said, it was on page 51, going right with what you're thinking, which as a human being makes sense. He said, we don't believe she should be barred from taking assets from the estate, especially for the damages she sustained. Well, this is not a damages case. And that's the tricky part. And so, yes, when you first look at this at first blush, and my reaction is the same. Who is this blankety blank guy that beat up this woman? And in fact, I apologize to her in court that we had to go through it in court. I said, Ms. Peacock, I'm sorry you went through that. And I'm sorry I had to question you about that. But that's not what this case is about. That's what we see because we know about domestic violence and we should take strong action against that, and nobody can condone that. But that then goes to the criminal fact that he went to jail. And then we look at what happened after that. I agree with the court. He shouldn't be taking anything from anybody's estate. But I don't think that we can ignore 17 years going by, the fact that he didn't have anything, the fact that she did live with 2 other men, and that was voluntary. And I get the court's point. Well, what else was she supposed to do but go on with her life? I agree with that. But there's got to be some point, and as you know, the courts of equity and the courts of law are merged in North Carolina. So this is a place for equitable considerations as well. And so I would say,
Courts of equity and the courts of law are merged, then are her, and I understand this is not a damages case,
right.
but is that argument by Mr. Smith included in that merged analysis, or is it just too remote to really not?
It's not a damages case. Yeah, right. I think that is too remote. This is a case about what somebody has in their estate and who's entitled to get it. And she says, I'm entitled to get it because I was his spouse at his death. And we say, well, because of what happened after y'all's separation, we don't think you should have rights to that property 17 years later. And what the other side is saying is they're saying, well, because she left based on domestic violence, none of that other stuff matters. She left because of domestic violence. And so we don't look at the 2 divorces she filed. We don't look at the other men. We don't look at the fact that she said she wouldn't divorce him in 98. And again, not disagreeing with anything the court has said about all the factors of domestic violence. But just looking at the facts as to what has happened, we don't think it's fair that these folks, the bachelors, aren't able to take what they're supposed to take because this lady's come in and asked for it when the debt that she had to her and any restitution, if there was any, I don't know, I wasn't part of that in 98, 99, but that was the criminal case, and he got what was coming to him for the criminal case. And I'll entertain any questions.
I was just going to say, I think clearly this court has ruled that even though it was 17 years that they were apart, clearly at the end of Mr. Meetze's life, she was still married to him. And the question of whether she left him, and clearly the trial court found that, and then I think the trial court does go to an equitable kind of balancing that because so much time passed, because she did make 2 attempts to divorce him, did attempt or did live with someone else, that constitutes willful abandonment such that it overrides her abandonment. I mean, that seems like what we're weighing here. And
the last thing, if I may put it, the last thing I'd say is if you find that it's incorrect that that she did not abandon him, that still leaves the fact that she voluntarily separated. And those are 2 separate, in the 31A, one is voluntarily abandoned. That's a choice of will. That's you decide to choose. The other one is without basis,
Just cause.
without just cause. So there's 2 different things there.
Would that not have to assume then that they got back together, or that there was a rejoining?
I don't know that there was
to be a subsequent abandonment.
Well, it's my understanding there was no rejoining of them. There was the conversation or the letters they had between each other when he was in jail.
Okay. All right. Any other questions from the panel? Mr. Eagles, you want to just sum up?
If you'd like for me to sum up just what I've said, the clerk did the right thing by allowing my folks to have a right of appeal. Otherwise, they would have lost their due process rights. As we've talked about, we contend that, along as Judge Blunt found, that the activities that occurred after the domestic violence show that she was abandoned. Thank you.
Thank you very much.
Your Honor, may I take 2 minutes and do a brief rebuttal of a few points?
You want 2 minutes plus, or the entire rebuttal is going to be 2 minutes?
Yes, ma'am. Just 2 minutes if I could rebut a few points Mr.
Yes.
Eagles made. Thank you. Judge, just briefly, Mr. Eagles brought up the due process argument as to his clients not being notified. I would like to point out that they were not required to be notified. Chapter 30, which sets out who needs to be notified upon the filing of an application assignment of year allowance, I believe it says the spouse, who was our client, the clerk, and the personal representative of the estate if an estate has been opened. And there was no estate open. That will was filed back in July of 2017, sat there almost 2 years, no one opened an estate. Therefore, they were not required to be notified, so there was no due process violation there as to the Rule 60 order. Judge, next I'd like to make a few points about the abandonment issue. When we get to the equities and things like that, I would point out that not only was our client, Ms. Peacock, physically injured, she suffered emotionally and financially. She testified she had medical treatment, she had medical bills, she was out of work for a while. Not only all of that, but he also reaches down while he's assaulted her, takes off her wedding jewelry, her wedding band, and some other jewelry and takes off. There was a lot more that she went through. And what I would argue to the court is our legislature could have somehow tied this to Chapter 50B and got into, separate property, marital property, divisible property, but they chose not to. Again, the only question here under 31(1)A is, and the spousal allowance statute is, was she the lawful spouse at the time of his death? She was, and is she barred by law from taking under his estate? That brings us back to 31(A)(1), subparagraphs A2 and 3, as to the voluntariness of it and the willfulness of it. And again, the trial court's own order states that she initially left and it was unwillful and involuntary based upon domestic violence. I would argue we're going back to the initial time of separation, and at that point, there's no question that she was forced out, she was constructively abandoned, and that lies with Mr. Meetze. Thank you.
Anything further in rebuttal? Any further questions from the panel?
No, I have none.
Yeah, thank you.
Thank you. I'd like to thank counsel for your participation, for your arguments today. We certainly appreciate your participating in this virtual platform. And without further ado, I think we're in court now, Mr. Clerk.
Thank you, Your Honors.
Thank you. Thank you.
Thank you all.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Mr. Wood, should we leave the event now?
Yes.
Thank you.